if the court recalls, and I don't remember if it was your case, Your Honor, or Judge Hunter, I'm looking now, but this is the one where he was convicted of stealing multiple bottles of vodka from Family Fare, charges of larceny in a building because he also stole the caps that are not offered for sale, and then was allowed to go to rehab in lieu of immediately going to jail and staying there. So this is a situation where clearly he is not going to follow the orders of the court. And if he, as he indicated on the record today, returned from rehab, but did not immediately turn himself into the jail as he was required to do, but instead went home, that's further indication he's not going to follow the orders of the court. And we think if there's not time holding him in jail on the other charge, we think a higher cash bond is appropriate, or he's just going to continue to get intoxicated and continue committing larcenies as he's done for what, the past 15 years.
Okay, we'll go on the record. This is People versus Ryan Allen Klaus, case number 2442954-FY-3. This is arraignment on a felony charge here. And for the record, the court is presiding over this matter on behalf of Judge Cooper here today. If I could have both the attorneys put your appearances on, please.
Thank you, Your Honor. For the record, my call on behalf of the people.
Larry Brown on behalf of Mr. Klaus.
Okay, Mr. Brown, you've had a chance to talk to Mr. Klaus today.
I guess I have, Your Honor.
Have you had an opportunity to go through his rights with him?
Yes, Your Honor. As the court probably remembers, Mr. Klaus was recently sentenced by this court just last month.
Right, exactly. Have you had a chance to go through this new charge with him?
I have not, because I mean, it was a larceny in a building is what he's charged with. He was unaware of what this charge was, or didn't really have knowledge of it. And I guess I'm a little curious because actually I just a couple of seconds ago here just received the summons on it. The date of the alleged offense was August 12th, which was looks like today. I thought he was under sentence and in jail.
All right, Mr. Rolla, maybe can you shed some light on this for us, please?
I can, Judge. That the date should actually say August 10th. It was Saturday, early morning hours. I know because I had to come in and do the warrant for the matter and to enlighten the defendant on it, since he admitted to the theft law enforcement officers regarding stealing silver dollars from the residence located at 310 North Otsego Avenue, Apartment C. I think he should have a very good memory of what it is. In addition, as to the confusion that Mr. Brown has, the people were also confused because supposedly back on July 3rd, 2024, in case number 246718FH, Mr. Klaus was sentenced on a charge of larceny in a building. He was given a sentence of 6 months with credit for 9 days. And how he can be out on jail on August 10th, I have no idea.
All right, Mr. Klaus, were you in jail on August 10th, or had you been released?
No, I actually just got back from rehab. And then I was going to be coming back to jail the next day.
So you were out of jail in rehab when this charge allegedly arose on August 10th. Is that correct?
I just got back from rehab. Like, I just took the bus back to my house. I just got home.
Yeah, but you weren't in jail is my point.
No, I was not in jail. No.
All right. So Mr. Brown, I'm just going to treat this as just a typical arraignment on felony charges, and we'll go from there. So Mr. Klaus, I'm going to advise you of all of your rights today. And we'll set this matter for a hearing, and we'll go forward with the normal procedure. So Mr. Klaus, you're charged in this case with 1 count of larceny in a building. The complaint alleges that you did commit the crime of larceny in a dwelling at 310 North Otsego Avenue, Apartment C, by stealing 4 silver dollars. And you're being charged as a habitual third offender. And that makes the maximum possible penalty in this case up to 8 years. Do you understand that?
I do.
Okay. You do have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at a trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all your rights?
I do.
Okay. You also have the right to have an attorney present at any subsequent proceedings. If you cannot afford attorney, one would be appointed for you at public expense. Mr. Brown, my understanding is that Mr. Klaus has already been screened and approved, and you've been assigned as his attorney. Is that correct?
That is correct, Your Honor.
Okay. How does what plea do we want to enter here today as to this charge?
I'm not guilty plea at this moment, Your Honor.
Okay, so Mr. Klaus, the court's going to enter a not guilty plea on your behalf with regard to this charge. And then we'll set this for a pre-trial hearing. That's going to be your next appearance in court. That's going to be on August 21st at 10 a.m. And we'll give you a written paper that gives you all the dates and times of your hearings coming up. In terms of bond, pending that hearing, I believe bond was already set at $5,000, 10%. Mr. Rowland, are the people asking for any kind of modification of bond?
Judge, it all depends. If he was supposed to be returning to jail, which as I understood he was supposed to after getting out of rehab, he may very well still have time left on his sentence in case number 246718FH. If he does not,
I do still have time. I do still have time left.
Hold on, Mr. Klaus.
Okay, go ahead, Mr. Rowland.
thank you, Your Honor. If he does not, then yes, the people would specifically ask for a higher bond because clearly after being given the benefit of going to rehab to instead of going to, quite frankly, where the people asked that he would be sent, if the court recalls, and I don't remember if it was your case, Your Honor, or Judge Hunter, I'm looking now, but this is the one where he was convicted of stealing multiple bottles of vodka from Family Fare, charges of larceny in a building because he also stole the caps that are not offered for sale, and then was allowed to go to rehab in lieu of immediately going to jail and staying there. So this is a situation where clearly he is not going to follow the orders of the court. And if he, as he indicated on the record today, returned from rehab, but did not immediately turn himself into the jail as he was required to do, but instead went home, that's further indication he's not going to follow the orders of the court. And we think if there's not time holding him in jail on the other charge, we think a higher cash bond is appropriate, or he's just going to continue to get intoxicated and continue committing larcenies as he's done for what, the past 15 years.
Thank you, Mr. Brown.
Thank you, Your Honor. And this case, again, just came up this morning. I am familiar with his previous case. This court did sentence him to 6 months in jail, 9 days credit. He could be released to residential treatment if a bed was available. I guess I am not that familiar with the inner workings. Apparently, it may have been up to him to transport himself and transport himself back. Because that is the only way that these alleged charges could have occurred on this date. But this was back in July 3rd. So he still has another 5 months to serve. To be quite honest with the court, bond is not going to matter at this point because he is serving another 5 months in jail.
All right. I mean, I'm satisfied that Mr. Klaus, based on his previous felony case, is going to be lodged for at least the foreseeable future in terms of the next few dates in this new case. So the court is going to leave bond as set by the magistrate at $5,000, 10%, subject to all the conditions set by the magistrate. And then again, this case will proceed on August 21st with the felony pretrial. Mr. Rolla, anything further that we need to address from your side on this file today?
Judge, just the only, and I guess I understand the court's ruling, but I'm a little bit confused as to how he could even qualify for a 10% bond if this offense was committed while he was under sentence for another felony. But in any case, since he's serving time, it's at this point effectively a moot point, so I'm not going to belabor the matter, Your Honor.
Okay, all right, thank you. Mr. Brown, anything further from your side?
I have nothing further substantively, but if the court could please just give me that file number one more time.
This current file number?
Yes, Your Honor.
Sure. This is 24-42954-FY-3.
Thank you, Your Honor. I have nothing further.
Okay, Mr. Klaus, do you have any questions before we move on to our next case?
I don't, except that was actually, the address was my house. Just to let you know.
Mr. Klaus, don't talk about any of the facts of this current case.
Okay, that's fine. That's fine.
Okay. All right, thank you. And if there's a jail officer in there, if we could have Mr. Heron next, please.
Yes, Your Honor.
Thank you, Your Honor.